Welcome back to the second video in this series. As I mentioned in the introduction, the real question here is whether Google's initial book digitization can be justified in terms of the fair use doctrine. I will discuss the application of the traditional fair use factors listed here over the next 15 minutes or so to give you an idea of how this question was likely to be resolved by the court. The first fair use factor pertains to the purpose and character of the use by the defendant. According to the U.S. Supreme Court, transformative use is at the heart of the fair use doctrine. A use is considered to be transformative if it adds a significant new dimension to the original creation. Copyright law exists to promote creativity. Transformative uses are protected because they lead to the creation of new works which don't substitute for the author's original expression. The question then becomes, of course, is the book digitization Google has engaged in such a transformative? This is an area where Google is on solid ground. Google can point to a number of cases relating to similar technology where the courts have found that this kind of intermediate copying is both transformative and thus ultimately amounts to fair use. In a recent decision about plagiarism detection software, the Fourth Circuit held that copying and archiving student term papers was transformative because the papers were used for an entirely different purpose, namely to prevent plagiarism. A number of courts have held that copying computer software in order to discover its functional compatibility requirements is a transformative use and a fair use. Likewise, in the context of visual search engines, the Ninth Circuit has held in two recent cases that using thumbnail versions of copyrighted photographs as part of a menu of search results is transformative and constitutes fair use. If the Google Book search engine is transformative, does it matter that it is also commercial? The short answer here is no. There are countless examples of commercial fair use. In its 1994 decision of Campbell v. Acuff-Rose, the United States Supreme Court clearly rejected the notion that commerciality by itself had any hard presumptive significance in relation to fair use. Instead, the court adopted a sliding scale approach to commercial fair use, explaining that the more transformative a use is, the less significant other factors become. Another element that significantly affects the purpose and character of the use here is Google's decision to give authors the ability to opt out of its book search engine. Google's position has been that it will keep scanning books and incorporating them into the search engine until it receives an instruction to the contrary from the copyright owner. Opt-out mechanisms like this are actually quite common on the internet. For example, a traditional internet search engine is programmed to scan every website in its path unless it receives an instruction from that website in the form of the Robots Exclusion Protocol telling it not to. The Robots Exclusion Protocol is the internet's equivalent of a no trespassing sign, but the assumption otherwise is that computers can walk wherever they like. Why should the choice between opt-in and opt-out make a difference? Well, in a world without transaction costs, it doesn't. If 75% of authors wanted to be in the Google Book search engine and only 25% did not, then if you start from all in and take 25%, or start from all out and add 75%, you end up at the same place. But in the real world, transactions costs are in fact quite high. And where transactions costs are high and asymmetric, the choice between opt-in and opt-out can really make a substantial difference. In the context of the Google Book Search project, it seems likely that the opt-out makes the purpose and character of this digital scanning more fair, subject to three conditions. First, a majority of copyright owners either favor or at least don't object to their works being included in the search engine. Second, the expected cost of proactively obtaining permissions is very high. And third, the costs of taking advantage of the opt-out are sufficiently small that the autonomy of those authors who don't want to be involved with the Google Book search engine is effectively preserved. We can't say for certain whether Google would have been successful in establishing these three elements. However, it seems more likely than not based on what we know at the time being. The second fair use factor is the nature of the copyrighted work. Two distinctions are particularly important here: the difference between published and unpublished works, and the difference between informational and creative works. The first of these distinctions appears to favor Google, as the overwhelming majority of library books are published. As to the second distinction, it's obvious that many of the books being scanned by Google will be informational, but many will be expressive. Nevertheless, the same body of case law which elucidates these distinctions in the first place also suggests that this second factor is not likely to be particularly important in a case such as the Google Book controversy. The Supreme Court has noted that the second factor is rarely likely to help much in separating the fair use sheep from the infringing goats in a parody case, and subsequent decisions have confirmed that the utility of the second factor is limited where the creative work is being used for a transformative purpose. Like so many other cases, the significance of the second factor would probably have been overwhelmed by other considerations here. The third factor that a court must consider in any fair use determination is the amount and substantiality of the portion used by the defendant in relation to the copyrighted work as a whole. There is no magic number that determines how much copying is too much for the fair use doctrine to apply, because the extent of copying consistent with fair use varies according to the purpose of the copying by the defendant and the effect of that copying on the copyright owner. In particular, Google could point to a significant body of cases where total literal copying has been accepted as fair use. The seminal fair use case of Sony v. Universal is just one example, and several others are listed on this slide. The most important cases here will be the Aribasoft case, the Perfect 10 case, and the Field case. In each of these cases, the relevant court determined that the total literal copying required by the search engine technology at issue was justified under the fair use doctrine because that copying was for a fundamentally transformative purpose. This presentation is continued in the next video.